attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Regulation A. The new Regulation A actually divided Regulation A into two offering paths, referred to as Tier 1 and Tier 2. Tier 1 remains substantially the same as the old Pre-Jobs Act Regulation A, but with a higher offering limit and allowing for more marketing. The old Regulation A was limited to offerings of $5 million or less in any 12-month period. The new Tier 1 has increased that to up to $20 million in any 12-month period. Since Tier 1 does not preempt state law, it is really only good for offerings that are limited to one or a small handful of states. Tier 1 does not require that the company include audited financial statements and does not have any ongoing SEC reporting requirements. Accordingly, Tier 1 is not likely going to be used for going public transactions. Both Tier 1 and Tier 2 offerings have minimum basic requirements, including issuer eligibility provisions and disclosure requirements. Both have affiliate resale restrictions. Resales of securities by selling security holders are limited to no more than 30% of a total particular offering for all Regulation A offerings. For offerings up to $20 million, an issuer can elect to proceed under either Tier 1 or Tier 2. Both tiers will allow companies to submit draft offering statements for non-public SEC staff review before a public filing, will permit continued use of solicitation materials after the filing of the offering statement, and both use the EDGAR filing system for filings. Tier 2 allows a company to file an offering statement with the SEC to raise up to $50 million in a 12-month period. Tier 2 preempts state blue sky law. The offering statement is a little less lengthy than a traditional IPO registration, though a Form S-1 format is permitted and is even required if the company intends to become subject to the full SEC reporting requirements by filing a Form 8A, or if it intends to apply for a listing on a national exchange. The SEC review process is a little shorter, and a company can market in a way that it cannot with a traditional IPO. The trade-off is that Regulation A is limited in dollar amount to $50 million for a Tier 2 and $20 million for a Tier 1. There are specific company eligibility requirements, and there are investor qualifications and associated per investor investment limits. Also, the process is not inexpensive. Attorney's fees, accounting and audit fees, and of course, marketing expenses all add up. A company needs to be organized and ready before engaging in any offering process, and especially so for a process that will be filed with the SEC, such as Regulation A. Even though a lot of attorneys, myself included, will provide a flat fee for the process, that flat fee is dependent on certain assumptions, including the level of organization of the company. I'm attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.